The Honorable, the Supreme Court.
Morning, everybody. Thank you very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont v. Richard J. Chamberlin, case number 24 AP 328. Representing the appellant, Richard J. Chamberlin, is attorney Alex John. Representing the appellee, State of Vermont, is attorney Evan Meenan.
Okay, thanks. Good morning again, counsel. Come on up, please. Attorney for the appellant, please, for the record, introduce yourself and your client.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court, Alex Don of the Office of the Defender General for Appellant Richard Chamberlin.
Thank you.
As to the Brattleboro count of sexual assault in this case, the complainant had no memory whatsoever of the alleged incident.
So we're clear, Mr. Dunn, count number 3.
Count number three. There was some confusion, but I've referred to it as count number 3 of the amended information. The complainant said that their mind was just black as to what happened in the shower, and that the incident or whatever did or didn't happen in the shower had just blanked from their mind. Beyond saying that they felt sore upon leaving the shower and experienced, I believe it was a racing mind that was similar to a previous experience, they offered no evidence whatsoever regarding anything that took place or didn't take place in the shower. This is just simply not enough. In State versus Duranlo, this court in 163 Vermont 8, this court reversed a murder conviction and emphasized that at some point rational inference leaves off and speculation begins. That is unfortunately what happened in this case as to count 3.
There was a circumstantial evidence charge that was included as part of the jury charge. Couldn't the jury make an inference that the testimony, we'll leave aside the prior bad acts issue, but the testimony itself could lead to an inference that it actually did occur?
Your Honor, I think the jury certainly could have, there was a circumstantial evidence charge, and I think the jury certainly could have been led to the conclusion that a sexual assault may have happened. But I don't believe that based on what they heard at this trial, they could have rationally concluded beyond a reasonable doubt that a sexual assault in fact occurred. There was no evidence that an act occurred. There was no evidence of the defendant's intent. There was no evidence whatsoever that any soreness was the result of any sexual assault or some other reason. So circumstantial evidence at some point, the jury is just speculating. And I submit respectfully that that's what happened in this case. Honestly, this is a situation in which the entire crime needs to be inferred, the entire crime. And I would respectfully urge the court to look closely at this and ask, is this enough?
So where does rational inference leave off and speculation begin?
These are fact-specific inquiries, of course, and every case is different. And I would just submit in a case where not only is there no independent third-party witness, no DNA, no corroboration, no video, but even where the complainant themselves is unable to describe an incident at all, I would submit, Your Honor, that we can at least establish that the line, that this is below the line. And whether or not in a given case, there may be slightly more evidence or more evidence that becomes a closer case, that's for a different day. But no description whatsoever of the incident by anyone, insufficient evidence, shouldn't have gone to the jury and frankly tainted the trial.
But Attorney Dunn, isn't this really, at the end of the day, an issue about credibility? Isn't it that for the province of the jury and not this court?
Respectfully, as to this count, Your Honor, I disagree because The complainant did not describe a sexual assault. Had the complainant described a sexual assault, the jury might be in a position to determine whether that testimony was credible. And the jury was certainly faced with similar credibility determinations as to the other counts, and I'd love to discuss the uncharged acts evidence. However, as to this count, even if the jury credited the complainant in this case, and let's give the jury, let's take every determination regarding credibility in the state's favor on this, they would have determined that that she took a shower, she stepped out of the shower, she didn't remember what happened in the shower, even crediting she felt sore, even crediting that she felt sore in a way that was similar to a way she had felt an undisclosed amount of time previously during the Vernon incident. It's just simply not enough to establish that a sexual assault occurred.
So how does the Massachusetts actions play into an analysis of count 3 or analysis of the overall case?
Thank you, Your Honor. It plays in because what it really does is that it really demonstrates that the real reason the Greenfield evidence was admitted, and the only reason that it was actually used on summation was to prop up the weak, unremembered, charged Brattleboro incident.
Context.
I'm sorry.
The judge said context. It's used for context.
The judge did say that, and this court has said that the prosecutor and presumably the court doesn't get to just say context. They have to show, as this court has emphasized, precisely how the uncharged evidence is relevant to a contested issue at the trial.
Do you have a working definition for context?
I don't have a working definition for context. I do know that these are fact-specific inquiries, and what I think is more important than, and this is this court, what is more important than catchphrases or buzzwords is how, in fact, is the evidence actually being used at the trial. And I just reread the summation again by the prosecutor in this case. I'm not talking about the R.4 right now, but I read it to see how did they use this evidence. And the only way the prosecutor referred to the Greenfield evidence in this case was not to talk about a delay in reporting, which was covered by another witness. It was not to say, this isn't a case of alleged incest, and you have to understand it happened more than once, otherwise you won't believe it. Didn't say any of that. He immediately, I don't know why I'm looking at this, it's not the right paper, but in something like the third paragraph of his closing statement, the prosecutor said, you have the Greenfield evidence, and it's important, I'm paraphrasing, it's important because they didn't remember the Brattleboro alleged sexual assault count, but you have the Greenfield evidence, and you can sort of put them together and see that he must have done in Brattleboro what we know he did in the uncharged Greenfield evidence, and call it context. And I want to be quiet if you'd like to ask a question, but I have so much to say about this. It is put any label on it. You know, you can say the word context a million times, but what the prosecutor was actually in fact doing was saying, you should believe that he sexually assaulted someone in Brattleboro, even though there is zero evidence of it. Because we know that we have testimony that he, in fact, if you believe it, did this act in Greenfield. That is exactly what this rule is designed to prevent. Call it context, call it plan, call it scheme, call it delay, call it whatever you want. That is what is not supposed to
But
happen.
they testified there was a shower. They testified there was discomfort. They testified that it felt bad from Brattleboro. Or something.
Roughly, yes.
And then they testified to specifics of what happened in Greenfield.
Correct.
So couldn't the jury make a reasonable inference on that?
But well, if we're on point one, insufficiency argument is not enough. If we're on point two, which is the uncharged acts evidence, no, to the extent that Your Honor is saying, I take the question as saying, couldn't they fill in the gaps of what they didn't hear about Brattleboro with evidence of what they did hear about Greenfield to say that, well, he has a propensity to do this because he did it in Greenfield. We didn't actually hear it in Brattleboro, but we can fill in the gaps. Respectfully, labels aside, that is exactly what is not supposed to happen at a criminal trial. When you read the summation, when one reads the summation by the prosecutor in this case, the only reason this evidence, this Greenfield evidence is mentioned is to prop up the Brattleboro count.
And Mr. Dunn, filling in the gap is not the same as an inference.
Filling in the gap is not the same as an inference.
That the jury can draw. It's just too much of a leap.
Well, again, as to point one, it's too much of a leap. As
As a
to point
counselor.
two, on the Greenfield, my argument is slightly more nuanced. It's filling in the gap to create an inference about what actually happened is not a permissible use of Rule 404B evidence. And even if any of this, even if the court disagrees with anything I've said about whether any of this evidence was admissible, because I understand that there are many decisions by this court indicating in various circumstances that the word context can mean a lot of different things, that the exception is not hard and fast, that this evidence tends to come in. Even if the court were to disagree and find in this situation that it was somehow admissible for one of these purposes, it still violated Rule 403. That argument was preserved, but not only was it preserved, in State versus Shippey, and I'm sure I imagine in other cases, this court emphasized that a Rule 403 prejudice analysis comes hand in glove with a Rule 404B admissibility analysis, i.e., when the court admits evidence under 404B, it necessarily has to conduct a prejudice probative evaluation. And in fact, this court has
Attorney
found
Don, isn't the probative value here clearly linked that the alleged victim had no other way to explain the sensation other than to bring in the prior or comparable act?
I'm not.
Their perception of what occurred is inseparable from the other incident. That's what it appears to be the context. So how is it that the prejudice outweighs the probative value when that's fundamental to their experience?
Our argument would be that hearing direct testimony that the defendant, in fact, if you believe the complainant, committed a similar act at a later time, and that he was therefore the type of person who would do this, makes it highly likely that the jury would say, even though we didn't hear direct evidence of what happened in Brattleboro, we're just going to speculate and assume that that's what in fact happened. But it actually doesn't prove anything. The evidence of what happened in Greenfield doesn't actually prove anything. We're not talking about some sort of distinctive bruises after a certain kind of injury. We're not even talking, frankly, about very specific testimony about soreness or their mind racing. They said, my mind was racing and I felt soreness. They didn't say, I've never felt soreness like that in my entire life and it was in a certain way, or I had a bruise on this. It was all vague, even from a probative perspective. It was vague and full of gaps, even with the Greenfield evidence, but it was extraordinarily prejudicial.
If I could ask you one question, the standard, we've got a unanimous verdict here. The standard is only if there is no evidence. So are you saying that circumstantial evidence does not meet that standard?
Not at all, Your Honor. I'm saying this circumstantial evidence doesn't meet that standard. And when we're in this position, there's always going to have been a unanimous verdict. If there wasn't a unanimous verdict, we wouldn't be here. So this evidence just wasn't enough. I'd like to try to reserve a little bit of my time, but the last comment I'd just like to make, it goes to both one of the points that we raised and to harmless error on the Greenfield evidence, is that there was no curative instruction or no instruction regarding how to use this evidence. 2 quick points on that.
But you didn't ask for a curative instruction though, right?
Correct. Correct. So 2 points on this very quickly. On our argument, the evidence shouldn't have come in because it was inadmissible or Rule 403. Our argument is this court should just look at the fact that there was no charge when it considers harmlessness. That doesn't require us to argue plain error. That's just when you consider harmlessness, there was no charge. Independently, the only note I'd like to make regarding plain error is that My adversary argues that the lack of a charge was waived. We would submit that in light of this court's discussion of waiver versus preservation in Kanzior, that in fact, the argument was unpreserved. It was not waived. The distinction therefore means that this court can and should review it for plain error. I'll reserve my 1 minute. Thank you.
Okay. Thank you. We'll hear from the appellee. Please, for the record, introduce yourself and your client before you.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking the court to affirm appellant's convictions for molesting his daughter, VE. I'd first like to start off by addressing the sufficiency of the evidence regarding the Brattleboro count. And in that discussion, I'd like to start off with a point that Chief Justice Reiber made, which is the applicable standard of review. And this court has repeatedly said that a unanimous jury verdict should only be overturned when the state fails to present any evidence in support of that verdict or when there is no evidence in support of that verdict. The case that—
So Mr. Meehan, what's the evidence? Is the evidence the shower? Is the evidence the sensation? Is the evidence those, including the Greenfield event?
I think that's a really interesting question, because what the appellant would have this court do is really take a very narrow view of that question and focus solely on the sensation that occurred in Greenfield, which is certainly an important piece of circumstantial evidence, but it's not really the only piece of circumstantial evidence. And that is exactly why context is so important in these cases. What the complainant did here was describe a very prolonged series of abuses that she suffered at the hand of the appellant. And one aspect of those abuses was the sensation that she experienced in Greenfield that was relevant to the events in Brattleboro. But that sensation in Greenfield was also has to be viewed in context with what was the testimony that happened in Vernon. That same sensation was felt. So it's really, you can't just view one single aspect of the context and say, oh, well, that was insufficient. You have to view the entire narrative of the abuse, because that is the context. And there was a question as to what the definition of context is, and the state relies in its brief on the Forbes case, in which this court said that the history of defendant's incestuous relationship with his daughter was particularly relevant because it supplied the context. And then the additional statement was allegations of a single act of contact between a parent and a child taken out of its situational context of secrecy, oppression, and recurrence are likely to seem incongruous and incredible. The entire context was what started in Vernon and what ended in Greenfield.
Then why did the state need the Greenfield evidence? They could have just used the Vernon evidence.
Well, need is a very interesting word, and the appellant uses necessary.
Why did they introduce it?
Well, because necessary is not the standard. Relevancy is the standard. And the question is what happened in Greenfield make it more likely or less likely that VE was molested in Brattleboro? The state doesn't need to show that that evidence is necessary. It only has to show that it was relevant and that its probative value outweighed its prejudicial effect. And I would—
Isn't this context evidence creating the risk of spillover, where the jurors can take admissible and relevant evidence from one charge and just apply it to another? I think we heard the gap filling. So isn't there inherent risk that absent adequate instructions or alternatively clear evidence for a charge that the jurors will fill in because they are sympathetic to the alleged victim?
Well, I think that's the exact question that this court has to answer on this particular issue in this case, right? When does drawing rational inferences from circumstantial evidence become propensity evidence? And there was no specific limiting instruction in this particular case. However, both the rule and this court's prior case law is clear that no limiting instruction is necessary unless one is asked for. Well, where does that leave us then? And the state cites two cases, the Holcomb case, and this one, I struggled with the pronunciation, I'm sorry, Seerveld. Those are the two cases that the state discusses in its brief. And those two cases establish that when a court, even in the absence of a limiting instruction, a general charge that describes the charges that the counts that the defendant is charged with and for which the jury needs to reach a verdict, those are sufficient. So for example, in the Holcomb case, this court said, there is no reason to believe that the general charge limiting the jury to consideration of the act alleged in the information was insufficient. In the Seerveld case, this court rejected a plain error argument to the failure to give a limiting instruction by saying the court's instructions to the jury that the allegation against defendant was based on the charged incident eliminated any risk that the jury might be confused as to the conduct that formed the basis of the charge. The court's instructions in this particular case met the requirements of both of those cases. So to find for the appellant in this case on that issue that you just identified, Justice Thibault, would mean you'd have to reverse those two cases in the state's opinion. I would like to address two other issues related to this particular issue. The first is that,
Still on count three?
unfortunately, yes,
Okay.
but it's an important issue. All of these issues are important in this particular case, and I'm happy to change topics in response to any question. But there was some implication that this case was somehow unique or different and warranted reversal because there was no witnesses. There are rarely witnesses to cases involving the molestation of children. And that is exactly why this court has repeatedly held that context evidence is important.
Can you point us to another case where there's been a charge sustained on sensation alone? The sensation I felt was the same as what I felt some other time in some other place.
I don't recall in my research identifying a case that was 100% factually analogous to this one in the way that you just described. But I also want to address that, there was the appellant's argument that there was no description of the abuse that occurred in Brattleboro. Rather, there was just a reference to some of these sensations. In other words, this is focusing on VE's diminished memory.
Well, they had no memory of the event in Brattleboro.
That's correct. They were not able to describe the specific sexual act that occurred. However, as was pointed out during some of the questioning, the judges are the sole witness of credibility. And in addition, one of the reasons why
The jury, you mean, the jury's the sole creditor.
Yes, that's right. I'm sorry if I misspoke.
I thought you said judge.
The judge. Well, I guess if it had been a bench trial, but yes, the trier of fact is the sole judge of witness credibility, and VE's diminished memory is certainly something that could have been pointed out in cross-examination and during closing arguments. There is, however, the lack of a specific description is also one of the reasons why in this particular case, expert testimony is relevant and admissible to explain things like delayed disclosures. We know that there are multiple reasons why a witness might not be able to describe a specific sex act. An adult could have been incapacitated. A child may not be verbal yet. Even if a child is verbal, they may not possess the sophistication and the language necessary to describe these events. But again, those are all things that should be explored on cross-examination and in closing. It does not mean, however, that the state failed to present any evidence or that there was no evidence, which is the standard of review on appeal. In addition, there was the appellant during his turn at the podium tried to summarize what the state's closing was and how the state referenced the Greenfield incident. And he did so in an attempt to assert that the state actually was using this information as propensity evidence, and the state disagrees with that characterization. Obviously, the transcript speaks for itself. However, one of those transcripts is the May 2nd, 2024 transcript, page 16, and the state discusses this on page 11 of its brief. And there, the the appellant specifically acknowledged below that the state hadn't argued that, quote, because it happened in Greenfield, it must have happened in Brattleboro. The state was not making that argument. And the standard under Rule 404, and this is in the Katzum case, is that other act evidence is inadmissible when, quote, its logical relevance is limited exclusively, end quote, to propensity. However, in that decision, the court went on and said, if the evidence is admissible, quote, because it's relevant to some other issue, then its admission should be upheld. And in this particular case, the evidence of the Greenfield incident was relevant to other issues, including but not limited to context, as the court found.
Let's assume that the Greenfield evidence was not admitted. Was there enough for conviction without it?
My recollection of the evidence in this particular case, and excuse me if I'm summarizing this incorrectly, was that the reason why the Greenfield incident was relevant was because VE experienced sensations similar to the ones that she experienced in Vernon during the shower incidences. So I imagine if the Greenfield incident had been excluded, then what the state would have argued, and perhaps there was some allusion to this as well, was that the sensation that VE experienced in Brattleboro was similar to the sensations she experienced in Vernon, and in Vernon she did describe a sex act. Therefore, you can still draw the same rational inference from the circumstantial evidence that you would have been able to draw from the Greenfield incident. However, again, just because there was an alternative way to make the same argument to support the charge doesn't mean that the Greenfield incident was somehow irrelevant. Again, the standard is not necessity. The standard is relevance.
So it's a pattern of misconduct under Anderson. That is essentially your argument for the admission of the evidence under 404. Is that right, Attorney Mead?
That's certainly part of it. I mean, there was a couple of grounds that the court admitted this pursuant to 404, one of which was context, one of which was to explain the delayed disclosure. And then there is the issue that the appellant raised as to whether or not that evidence was still relevant to show a pattern of misconduct, notwithstanding the dismissal of the charge that was specifically based on that. And the state's position is that, yes, notwithstanding the dismissal of that charge, this evidence was still admissible to show a common plan or scheme. The state cites several cases, one of which was Anderson, as you just noted, but the Forbes and the LaBounty case are also cited in the state's brief. The LaBounty case I think is particularly relevant because it was also a 3253A8 charge, which is exactly the charge that one of the charges the appellant was facing in this particular case.
Attorney Mead, to bring this back around though to the issue of instructions. So we heard from counsel for the appellant about whether this is preserved or unpreserved or waived, but isn't that somewhat moot given Rule 26 charge that the judge shall instruct on this? And given the discussion here, this is all very nuanced, which legal professionals may understand, but how are the laypersons of a jury to distinguish between context versus explaining a delayed report versus using it for some impermissible purpose?
Well, I have two responses to that, Your Honor. The first is, in the Holcomb case, this court specifically addressed Rule 26C, and it said that that rule does not, quote, dispense with preservation requirements. So I think that case answers that question. The second issue is that this court has described the presumption that juries follow instructions as fundamental to our justice system, and the state agrees with that conclusion. And one of the instructions, as I mentioned earlier, was the fact that the court told the jury, these are the charges that the state has filed against the appellant. They are limited to acts that occurred in Vermont. Your responsibility is to determine whether or not the appellant is guilty of those specific charges based on the evidence that was presented. This court has to presume that the jury followed that instruction. And as I mentioned in the Searville and the Holcomb case, this court specifically said those types of instructions are sufficient, even in the absence of a limiting instruction. And in Searville, it did so in rejecting a plain error analysis. So even if this court were to engage in a plain error review, the state's position is that it would have to uphold appellant's convictions, even despite the absence of a specific limiting instruction. I am happy to answer any other questions, but I anticipate that light's going to go off in about 5 seconds. Thank you.
Okay, thank you. How much time does the appellant have, please?
Appellant has 54 seconds remaining.
All right, counsel.
Thank you, Your Honors. Just a few quick points. Number one, Holcomb does not stand for what my adversary just said it stands for. In Holcomb, the court gave a general instruction that the defendant was not on trial for any act not alleged in the indictment. It's possible that I missed it. I haven't been able to find that language in the charge. Furthermore, in Holcomb, the uncharged bad act was entirely different from
I
the
know
charge.
You're under a quick clock here, and maybe go off the clock just for a second. And this is not criticism in any way, but could you slow down just a little bit, please? Thank you. And it's not criticism.
No,
It's just,
I appreciate it. I appreciate
thank
it.
you.
I appreciate it. There were two differences between Holcomb in this case. The uncharged and charged incidents in Holcomb were different. That's one of the reasons there was no plain error in Holcomb. Also, I did not find in this court's instruction to the jury, I may have missed it, but I did not find an instruction that the defendant was not on trial for any act not alleged in the indictment. Regarding Your Honor's question, I certainly also look at the language of the rule as providing that the court shall provide the limiting instruction regarding the use of uncharged acts, period. And if the court wants to reverse Holcomb or reverse cases that it has previously held that preservation was required, my reading of the statute would support that. If the court finds that preservation is required, we suggest that the court review it for plain error, because in this case, the jury was not given any instruction regarding how to use the evidence beyond the amazing language saying you are not to consider it as propensity. The charge also tells the jury this is what you're supposed to consider it for. And we've been arguing for 30 minutes. I don't think it's very clear what this evidence was actually admitted for. And the jury, had it been told it's admitted for one limited piece. Yeah.
Thank you. Your time has expired. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.